Welcome to this last session of our course, The Law Philosophical Aspects. And in a way, we are returning to the beginning. For the question that we're going to be focusing on today is somewhat preliminary in nature, or at least that's one way of looking at it. And the question is, what is law? What is the nature of that phenomenon that we've been talking about? And the question is in some respects very basic. You may think that it's more basic than the other questions we have been asking. You may think, and this is going to be a suspicion that will return from time to time, you may think that the question is perhaps even too basic to be at all interesting or to allow for an informative answer. So we'll return to that suspicion as well. But first we'll do the best we can. It's important to note that this question is different in kind from the questions we have been discussing throughout this course. The questions we've been discussing, almost all of them, have been normative in nature. That is, they were about what we ought to do or what is of value or what people have reason to do, either as private individuals or more often as an institution via the law or the state. So think about some of the topics that we've been discussing throughout the course. We've been talking about moral and legal lack, which really comes down to questions about blameworthiness and about the justification of punishment and other legal responses. So that's about the justification of other legal responses. That's a normative question. We've been talking about the duty to obey the law. That's obviously a normative question right on its face. We've been talking about judicial review, and really the question that we were interested in there was whether any kind of judicial review can be ultimately justified, whether it's perhaps in tension with some basic democratic principles and so on. So again, a normative question through and through. Similarly, for whether it's a good idea to rely on statistical evidence, and for some of the normative issues surrounding the issue of discrimination. So these were normative questions. But what we're going to be talking about now is different. We have been talking about questions in morality, normative questions either in the vicinity of the law or within the law or about the law itself. But what we are going to be talking about today is what is often called conceptual questions. We're going to get to some more of these questions later on, but perhaps the basic one is, what is law? Here are some related questions. What does it take for a system of rules to amount to a legal system of rules, rather than many other systems of rules that we have about us all the time, like maybe rules of etiquette, indeed moral rules, rules of the faculty of law, rules of your tennis club, and so on. Right? Or what does it take for a norm to be legally valid? There are many norms around you all the time. There's the norm that you should, send a thank you note after a party, maybe eat using your left hand for the fork, serve and volley if you have a sufficiently strong serve, and so on. Right? There are many rules that we can mention. What's special to legal rules, if anything? Right? So these are not questions, as you will see, we'll notice. These are not normative questions. They're not questions about what we ought to do or what's justified or anything of the sort. They're questions about the very concept of law or legal system or legal validity or anything of that sort. There's at least a sense in which such conceptual questions are prior to the normative ones. Here's the sort of caricature way of looking at it. First, we need to know what we're talking about, then we can talk about it. And I want to acknowledge that there is something to this line, but as you may have noticed from my using the word caricature, I don't think that that's a good enough way of viewing things, because things are more complicated than this. Often when we're doing philosophy, we come to better realize the question as we consider some of the possible answers and the arguments for and against them. So the same thing is going to be true here. So I want to recognize that there is a sense in which conceptual questions are prior, but it's not every sense, and in particular, it's not a sense that would preclude us discussing some of the normative issues before discussing the conceptual one, as indeed we've been doing throughout this course. Okay, so I think the first thing that it's really important to notice about the law, and it's fairly trivial, at least once you think about it, is that the law is a social phenomenon. Now, there are different ways that we can understand such a way of talking, the different things that people mean when they say that the law is a social phenomenon, but we can at least say some of these things. For instance, clearly there are differences between the law across different jurisdictions. So what the law is in Israel today, and in the States today, and in Germany, and in Syria, if indeed there is law there at all, these are different questions. So the law depends on the society of which it is a part, at least in the way in which it renders it contingent on specific jurisdictions. So that seems fairly obvious. Another thing that's fairly obvious is that there seem to be causal relations between all sorts of social facts and legal facts. For instance, you may think that the fact that a certain line of thought becomes more popular in society has, usually after a decade or two, implications to the law. Or perhaps if Israeli society becomes much less tolerant of critical expression by academics and by NGOs and by perhaps people from abroad, you will expect to see legal arrangements, perhaps following after some time, that mirror this kind of general deterioration of democratic norms, as indeed we see when I'm taping this class. So it seems very natural to think that there are causal relations between all sorts of social phenomena, not necessarily legal phenomena, and the law. It's also plausible, although less obvious and perhaps somewhat more controversial, to think that there may be causal relations going in the opposite direction. That goes to the question of how influential is the law. So can there be legal arrangements that bring about other social changes? I think some people think, certainly in Israel, but probably not only in Israel, about changes in the general atmosphere, at least among certain parts of the population, vis-a-vis gay rights, as being partly influenced by the Israeli Supreme Court taking kind of front stage active role in securing many gay rights, and at least some social phenomena sort of followed suit. Of course, it's going to be very hard to establish such connections or causal relations in general. Correlations are one thing, causation is another, but perhaps there can be causal relations of this kind as well. Perhaps more interesting if we're doing now not sociology of law, but jurisprudence, or trying to study the concept of law, there may also be certain constitutive relations. So you may think that it's not just that all sorts of social phenomena have a causal effect on what the law ends up saying, but some of them actually make it the case that the law says one thing rather than another. According to such views, and we'll have more to say them later on, the content of law is not independent of social practice. The very content of law depends on relevant social practices. One way to see what we're talking about here when we're talking about constitutive relations is to think of some other social practices, like fashion, perhaps, or etiquette. If you think about norms of etiquette or norms of fashion, you don't just think of them as causally influenced by all sorts of things that go on a more sociological kind of level, but you think of them as being determined by relevant social practices. The fact that this and that trendsetter wears this and that thing in Paris in the fall, it doesn't just influence in a kind of causal way what the fashion norms then say, but it partly determines what they say. It makes it the case that fashion norms say this and that. That's all there is to fashion norms. A bunch of sociological facts of this kind, perhaps. And similarly, though perhaps in an even more complicated way, for the norms of etiquette. So you may think of legal rules as roughly along the similar kind of model. You may think that not what this or that person wore in the fall in Paris, but rather what those people, perhaps wearing robes, wrote in this or that official document. That's a kind of social fact that doesn't just causally influence the content of law, it makes it the case that the content of law is one thing rather than another. So you may think that legal facts are determined by social facts in roughly the same way as fashion facts and etiquette facts are, perhaps more complicated ways, or anyway, at least more bureaucratic ways, right? So there are no institutions of etiquette in anything resembling legal institutions. But still, at some level, what does the work are these social facts. So these are closer relations between social facts and legal facts than mere causation. And when we discuss legal positivism, we're going to come back to some of these. Okay, suppose you want to study fashion. And you don't just want to study a specific question, like for instance, you don't just want to understand men hairstyles in Jerusalem in 2017 or some such thing. That could also be a topic for research, but probably not for a philosopher. And this is not just a comment about philosophers' hairstyles. If you're a philosopher interested in the concept of fashion, what you want to know is something about fashion in general. You want to know what is it that makes some things fashionable and some are not, across, as it were, fashion jurisdictions. And it seems like here, what you need to do is not just sociology, but some conceptual analysis. You need to think about different possible scenarios. And under these different possible scenarios, what would and what would not amount to a practice worth the name fashion, or what would make a norm a fashion norm. Analogously, if you're a philosopher interested in the law in this kind of way, not the normative questions, but the conceptual ones about the nature of law, then you're not interested right now in specific jurisdiction. You're not asking about what is it, a question about what norms are valid in Israeli contract law today, or something like that. Rather, what you're interested in is legal validity in general, or what the concept of law is. Questions like we started with. What does it take for a system of rules to amount to a legal system? What does it take for a norm to be legally valid across jurisdictions, not just what the criteria for validity are within a jurisdiction? And these questions have a name in the literature. They're called general jurisprudence. The word general there is supposed to distinguish between questions, say, about the criteria of validity in a specific legal system and questions about the very nature of legal validity. So these are going to be the questions we ask today. And we're going to start with one example. This is the 19th century philosopher John Austin, who put forward one very well-known, although rather obviously false, theory that responds to such conceptual questions about the law. We're going to use it because it's a good way in, as it were. I don't think it's a good contender for the truth of the matter, but it's a very good way in. It's also extremely historically influential, so it's a nice way of understanding some of the contemporary debate against the background of Austin's view. Well, Austin is into definitions or analyses, and he offers his theory by way of a series of analyses, and here they are. A law, or as Austin sometimes says, because he knows that the discourse is not as disciplined as he would like it to be. So a law, at least properly so called, is a general command issued by the sovereign to his subjects. Now there are different concepts there that also need unpacking. Let's do that following Austin. A command is an expressed wish about the behavior of another, backed by a credible threat of a sanction. So I can make a request. I can ask you, would you mind opening the window? That would be me expressing a wish about your behavior, but it wouldn't amount to a command. But if I'm your commanding officer and you're my soldier, and I tell you to do something, to go over this other place or whatever, then I've not merely expressed my wish about your behavior, but there is in the background a reliable threat of a sanction, or so says Austin. That makes the expression of a wish into a command. We don't yet have a law, but we have a command. Some commands are particular. If the police officer tells you to stop, that's a particular command. There, it is backed up by a threat of a sanction, but it's not general. What it takes for it to be general is to apply to a class of cases, not a particular one. That's straightforward enough. You will notice that what it takes for something to be law, is not just for it to be a general command, but it's also something about the source, about who posits the command. And the answer, according to Austin, is the sovereign. So we need an account of sovereignty, and here's his account of sovereignty. A sovereign is a person or institution that enjoys the habitual obedience of others and that does not itself habitually obey another. So one way of viewing it would be as a kind of a pyramid, where all intermediate stages have some people obeying them, but they also have to obey the people who are, as it were, above them in the hierarchy. Well, except for one, right? That's the sovereign. It can be a person, a monarch, but it doesn't have to be a person. It can be an institution as well. So long as there is a thing such that it habitually enjoys obedience and it does not itself habitually obey anyone else or any other institution, then it amounts to a sovereign according to Austin. And so we get the law is a general command, a general expression of wish of behavior backed by sanction, issued by the sovereign, that is, by the person who enjoys habitual obedience and does not habitually obey to his or her subjects. I guess with Austin, to his subjects. Notice that this way of understanding what the law amounts to renders the study of law a part of the social sciences. This is not coincidence. This was crucial for Austin. It was one of the desiderata, one of the main things he was out to achieve. He wanted to show how law can be studied scientifically, that is empirically. And in order to do that, you have to understand its basic concepts in an empirically respectable way. So think about sovereignty again. There's nothing here about legitimacy. There's nothing here about, certainly not about, divine authorization or anything like that. It's really a part of sociology. Again, the analysis here is entirely conceptual. It's about what the law is. It's not normative. It's not about how we should go about making laws or interpreting laws or deciding cases or even following laws. It's just about what the law is. As I was saying, it was really important for Austin to render the study of the law a part of, well, sociology. He always emphasized the need to really strongly distinguish between what the law is and what the law ought to be. And I think he's right. We all tend to at least allow room in logical space for criticizing the law in something like the following way. Sure, I understand that that's what the law says here, but it shouldn't. We should change the law because what the law says is unjust or inefficient or unwise in some other ways. So I want you to see that Austin's analysis maintains that distinction in a very clear and unproblematic way. All you need to know in order to know what the law is are such things as, well, who around here enjoys habitual obedience and does not himself obey habitually? In what ways does he express his wishes about the behavior of others? Which subpart of these are backed by sanction and yet are sufficiently general? And once you know this, you know the law. Of course, that doesn't mean it's a good idea. It doesn't mean that the law is good. If the sovereign asks for your advice as a moral philosopher, you have a lot of stuff to say. The point is that so far you haven't said it. The account of what the law is entirely independent of what the law ought to be. And it's in entirely social, factual terms. So I already said that I don't think Austin is very convincing. Now, as I said, Austin offers his account as a conceptual analysis, as a series, indeed, of conceptual analysis, or what he calls definitions, the law properly so called, and so on. But of course, if that's the name of the game, if the name of the game is conceptual analysis, then we already know how to play it. And you play it by offering or trying to offer, or sometimes failing to offer, counterexamples. So let's do that. And here's one kind of counterexample. Can there be no valid legal norm without a credible threat of a sanction? So we know, of course, what Austin thinks, right? If there is no credible threat of a sanction, it doesn't even amount to a command, and so ipso facto, it cannot be a legally valid norm. But just think about the question intuitively. What if there's a legal norm, or what we would intuitively classify as a legal norm, applying to you, except you're rather confident that you can get away with it, with violating it? What I've just described seems entirely possible, but that means that on this occasion, the norm is not backed up by a credible threat of a sanction. And what that means, according to Austin, is that it is not even legally valid. Notice that he may say, or we may say in sort of revising Austin, either that it does not even amount to a command, or that it amounts to a command, but it doesn't have whatever else is needed for a command to amount to a law. But really, this is not what matters. What matters is not whether Austin is wrong in the connection between law and commands, or commands and sanctions. What's important for us is that he's wrong globally about the relation between legal validity and sanctions. That's way too strong a connection. Maybe there is some close relation between sanctions and legal validity, but clearly not as close as Austin wants them, so not as a necessary condition for the legal validity of specific norms. One thing you may think here, which we'll get back to a little later, is that perhaps the relation is not at the level of a specific norm, but rather at the level of legal systems. So you may think that there can be no legal system without being backed by a sanction. But within a legal system, it's okay if a norm exists and indeed is legally valid, even if that norm specifically is not backed up by a credible threat of sanction. So that's a possible way to go. I think it would be an improvement. Already it's not Austin, but it would be an improvement. In fact, even that much is not clear. It seems like we can imagine a community, Joseph Raz calls it the community of angels. These are people who are all motivated by the desire to cooperate, among other ways, by obeying the law. So they don't need sanctions. But that doesn't mean they don't need law, right? You still need, say, traffic rules or other coordination solving rules. And so it seems that, at least if you fill in the details in the appropriate way, you can have a legal system in that community. And that despite the fact that nothing there, not even at the level of the system, not at the level of the specific norm, nothing there is about a credible threat of a sanction. So perhaps we need an even deeper revision than that. So if Raz is right that there can be a legal system in that community of angels when there is no backup by a credible threat of a sanction at all, that means that the revision we need to introduce to Austin's theory is deeper than it may have seemed. So that's one kind of counterexample. Here's another. Think about Austin's analysis of sovereignty again. Recall just about habitual obedience, nothing stronger than that, as it were. Can we think of counterexamples? Can we think of, say, someone who is a sovereign but who does not enjoy habitual obedience? One example that comes up in the literature is a new sovereign, say a new monarch immediately after the demise of the old monarch. It'll be a huge stretch to say that at that point the new monarch enjoys habitual obedience. No one has obeyed him yet. But it seems that at least in some sense of sovereign, this is the new sovereign, right? Long live the king. So it's possible that there are problems with Austin's view of sovereignty. Now this was just a counterexample, but as is often the case with counterexamples, they don't just show you that the generalization is false, they also point in the direction of why. What is the deeper problem there? And many people think that the deeper problem with Austin's, or at least one deeper problem with Austin's understanding of sovereignty is something like the following. According to Austin, norms that are legally valid owe their legal validity, as it were, to their source being the sovereign, as the sovereign is understood by Austin, right? So it's as if you have first a sociological notion of sovereignty, and you get legal validity flowing out of that. But many people think that Austin got that entirely wrong. It's in the opposite direction that we want the relation. What we want is the sovereign to owe his sovereignty to the law. And we think of sovereignty as itself a matter determined by the law, typically by the Constitution. If that's how we think of the law, then there's a deeper problem with Austin's view of sovereignty. At that point, it seems weird to even talk about revision. What you need is just to reject Austin's theory of sovereignty, and with it, Austin's theory of law altogether. Or at least so it may seem. Here's one final point about the problems of with Austin. There are others which you can find in the literature. So it seems like the kind of law that fits Austin's analysis best is criminal law. Today we should say domestic criminal law, right? That's the kind where you really have specific norms that are, general norms, but about specific classes of behaviors that are backed up by a threat of a sanction. And so at least they fit in an initial way Austin's analysis. But they are really a minority within the law. They don't, if you sort of measure the volume of law, they're not that huge chunk of the law. They're certainly not all of the law. Think about really other parts of the law. You may think, for instance, about everything having to do with contract laws. What's the sanction there? Right? Or you're writing a will according to these or those rules. What's the sanction? I mean, there's something you can say. Austin does say you may think about voidness as a kind of a sanction. But that's already a threat. It's not a sanction in the exact way in which a criminal sanction, say, is. Right? So in general, what we can say is that Austin's analysis does not fit the non-criminal parts of the law as well as it does the criminal law. So that's one kind of law that Austin's analysis does not fit. But there are others as well. So it's often noticed that it's not clear how to squeeze into Austin's analysis international law, where it's not clear that it comes from a sovereign who, in the international arena, enjoys habitual obedience and does not himself or itself obey habitually. And it's just really not clear that there even is such a function. So if you think that international law is real law, you have a problem with Austin's analysis. I think it used to be more fashionable to question that premise, to say that maybe international law is not real law. It's another phenomenon that uses the term law because it has, I don't know, good PR or something. But I think most scholars today think that it is law. If so, we have a problem with, yet another problem with Austin's analysis. It's also not clear how to put into this picture something like custom-based law, which in some jurisdictions is very big and very, very important. Now, here too, there's something that Austin can say. Indeed, he does say Austin knew the law. And you don't have to teach a 19th century Brit about the centrality of custom-based law, right? And he had something to say about it. He thought that it does come from the sovereign by way of default, and the fact that the sovereign does not cancel the relevant custom-based law, that's how the sovereign endorses it or makes it his own, and that's how that still fits in with his analysis. But I think we can agree that it's at least forced. The fact that you need to tell such somewhat awkward stories in order to render the analysis adequate is already a shortcoming of the analysis. And so if we can do better, we should. And luckily, it seems like we can. So we're going to spend a couple of slides now on a theory that comes from H.L.A. Hart. That's his picture over there. Hart, in many respects, followed in Austin's footsteps. We'll talk about legal positivism in a short while. But he was also one of Austin's main critics. So he was some of the critical points that I mentioned come from Hart, others as well. And here's one crucial thing that he thought was missing in Austin, except for the specific problems we've been discussing. Austin was too much, as it were, of a sociologist of law. He was just interested in social facts, just in the empirical kind of stuff that we've been discussing. But he's been missing something. He's been missing the fact that the law, importantly, is normative, that there is something normative going on there. If you're missing that, you're missing the phenomenon you're trying to explain. So it's a good idea to try and give everything a kind of a scientific empirical explanation, but not if the price is to miss what you're trying to explain. And that's, in a way, the accusation. Perhaps the normative thing that we're missing is a sense of legitimacy. So the law comes with, if not legitimacy, at least a sense or an aspiration to legitimacy. Right? So we want a concept of law to be open to the possibility that there are illegitimate legal systems. Right? There may be a legal system, maybe in a non-democracy, maybe, I mean, you can come up with historical examples as you want. We don't want to say there can be no law there if it's sufficiently bureaucratic and maybe orderly and perhaps some other criteria are met. There can be law that does not enjoy anything like political or moral legitimacy. But perhaps there can be no law without at least the aspiration to legitimacy. Some aspiration to legitimacy. Certainly, when you think about how legal officials talk, they seem to incorporate something like an aspiration to legitimacy. They don't just tell you, look, you should do this or that, otherwise, here's the sanction, the credible threat of a sanction. They also think that you ought to respond to the law, that often you ought to obey the law. That if this is a case in which it's not the case that you ought to obey the law, this calls for some special justification or some special justificatory story. This is what Hart thinks, and many follow him on this, is central to the law. Indeed, a necessary condition that Austin misses. It's not legitimacy, because there can be illegitimate legal systems, but it's a not entirely cynical aspiration to legitimacy. If you have a system that doesn't even aspire to legitimacy, then it's not a legal system. So we want a better account of that. Here's one example that Hart gives. Think about just a neighborhood thug who issues commands. They are certainly backed up by a credible threat of a sanction. Now these commands don't amount to law, even according to Austin, because presumably they're not general and the thug is not a sovereign. Okay, so let's sort of upgrade the thug into a really systematic, bureaucratic thug who does enjoy habitual obedience. And, you know, just issuing all these particular orders can be a terrible headache, so the thug becomes somewhat bureaucratical and hires other, like, minor thugs and maybe issues some more general kinds of rules. Now, I actually think that you can fill in the details in such a way that what you end up having is a state and a legal system, though probably not a morally legitimate one. But Hart's point is different. Hart's point is the following. How does the thug think of himself? How do his officials think of themselves? If they only think of themselves as thugs, then that's not a legal system. A necessary condition, not a sufficient, but a necessary condition for it to be a legal system, is that they at least think of themselves as doing something that enjoys legitimacy. And that is true of many legal systems that, under criticism, maybe we have to conclude are not legitimate. But this aspiration to legitimacy is a necessary condition. If you're missing that, you're missing a part of what the law is, says Hart, I think quite plausibly. Okay, then, what do we want? We want to hold on with Austin to the thought that the law is a social phenomenon, like fashion or etiquette. And we want to give a kind of an analysis that's going to respect this, and it's going to be, at least as far as possible, in empirical, sociological kind of terms. But we want to do that while also maintaining, while still accommodating thoughts about the normativity of law, at the very least on the level of an aspiration to legitimacy. So we want to ground law, so says Hart, we want to ground law in social facts, but not those about sanctions and sovereigns as Austin does. We need a better, though still social, alternative. And so here's at least a part of Hart's suggestion. So think about fashion again, or etiquette. We need to better understand now social rules in general, right? When we view law in this kind of context, when we think about the law together with fashion and etiquette, really what we're talking about is a wider category, the category of social rules. And so what we need is to philosophize about them. What are social rules? What does it take for there to be social rules in a relevant community? And Hart's work is pioneering in this respect, which is one of the reasons why it's pretty much the only work, as far as I know, the only text in analytic general jurisprudence that's being taken seriously by philosophers outside jurisprudence, because there's a lot of interest in social rules in general, not just in jurisprudence. That's mostly his work, the series of lectures that came out as a book called The Concept of Law. Well then, what does it take, what makes it the case for a certain social rule to exist? And that we want an analysis that's going to be content neutral, an analysis that's going to apply to fashion rules, to etiquette rules, to legal rules as well. So what does it take for such rules to exist, to regulate behavior? Here are some suggestions. One suggestion is that such a social rule is in place if everyone acts according to the rule all the time. Right? That's at least we understand the suggestion. It's attractive in some respects. But it's obviously false. It's really very, very strong. It's way too strong. Clearly, social rules can survive at least occasional violation. So it can be a social rule around my faculty of law that no one teaches wearing short sleeves. That can be the social rule, even if every once in a while a visiting professor teaches a class in June wearing short sleeves. That will not make it the case that the social rule is not there. Or think about other etiquette rules and so on. So that's too strong a requirement. It's also too weak because there can be things that satisfy the requirement but that do not really amount to social rules in the intended sense. So think about maybe commonly used strategies, right? Perhaps if you are if you play tennis, if you have a strong serve and you're playing on a grass court, you should serve in volley. And it's quite possible that among some circles, everyone uses that strategy, tentative or conditional though it is. But you don't want to say that that's a social rule there, in the same kind of way in which etiquette or fashion rules are. And there may be other examples as well, like prudential rules. These are rules about how it's probably a good idea to behave for your own first-person interests. Still, these are not social rules in the intended sense, or anyway, arguably, they aren't. So the requirement that everyone act according to the rule all the time is both too strong and possibly also too weak to be a good requirement for what it is for a social rule to exist. Here's an alternative then. How about the following? You have a social rule existing in place governing behavior in a certain context if most people act according to the rule most of the time, and also those who don't get punished. So this now allows for some violations, right? But it's still too strong. It's too strong because it gives too much weight to the sanction. A part of the point of distancing ourselves from Austin was precisely not to accord such a central place to a sanction. And you can see why. Just like rules can survive their own violation, rules can also survive their own unpunished violation. So even if no one looked badly upon that visiting professor who taught with a short sleeve, that still doesn't mean that that rule is no longer in place. or something like that. Okay, so it's too strong. It may also be too weak. We don't just want social rules to be about regularities. It's not just something you have a look and see that most people act in this way, or that when they don't, they suffer some consequences. We wanted to have something about legitimacy, something about something normative. So that won't do either. Here's Hart's suggestion then. And again, remember, it's called Hart's practice theory of rules. It's a theory of rules. It's not necessarily a theory of legal rules, though the law is not far behind. So, there is a social rule in a society, a social rule R in society S, if and only if. First, most people in S actually act according to R most of the time. So if no one really cares about the rule and no one behaves accordingly, then there is no social rule to that effect. That makes sense. But that's not enough, right? We don't just want regularity. The other main thing, and Hart's main innovation here, is that another necessary condition for a social rule is that most people in the relevant community accept the rule from what he calls the internal point of view. And here's how he fleshes it out, at least roughly. They accept the rule from the internal point of view, meaning that they refer to the rule in justifying their own behavior, or in deliberating, trying to decide what to do, and say, oh yeah, but around here, you don't wear short sleeves to class. So when they stand in front of their closet and they're trying to decide what to wear, it guides their behavior. And they, if you ask them, but it's a warm day, why are you wearing long sleeves? They're going to refer to the rule. So that's one element in accepting the rule from the internal point of view. And the other is a response to violations. But it's not necessarily a sanction response. It's a critical response. And it's a critical response, once again, referring to the rule. So people are going to say, well, why do you look, why do you criticize that person? Well, because, and then they will refer to the rule. There's a violation of that rule here. So I hope you see that this captures a sense of legitimacy. It's not a sense of legal legitimacy again. You can see that by considering fashion and etiquette again. So think about a group of people who care deeply about fashion rules. Among that community, those rules are going to have this status. Most people are going to abide by the fashion rules most of the time. But furthermore, they're going to be accepting them from the internal point of view. They're going to be referring to them in justifying their own behavior, or in bringing their own deliberations to a conclusion. And they're going to be criticizing someone else for being, I don't know, so 80s or something, by reference to the fashion rules. Similarly, for etiquette rules. That's what captures the thought, or the missing part in Austin, namely the thought that there's something normative, something about legitimacy going on, or something about, it's sometimes put in terms of bindingness. It's the internal point of view, the thought that rules are accepted from the internal point of view, that captures that. It also nicely captures the distinction between being a spectator and an insider. So think about being a fashion anthropologist. You don't care about these things. You just view the community of the people who do care about fashion, and you describe what's going on there. You can describe the regularities just as much as anyone else, just as much as any insider can. In fact, you may become an expert to the extent that you can predict who will wear what better than what the insiders can. That's a possibility. But you're not accepting the rules from the internal point of view, because you're not referring to the rules in guiding your own behavior, or in justifying your own behavior, and you're not criticizing anyone for missing them. You are merely describing regularities. The anthropologist is a spectator, at least, according to the typical picture of an anthropology. I'm sure that methodology there too is more complicated than that. The internal point of view captures the way in which, if you're an insider, you're different. You don't just view the regularities from the outside, as it were. You take a part in the practice by guiding your behavior according to the rules and criticizing violations by reference to the rules. It's at least worth thinking about, regardless of the law. It's something that you may want to think about when you're thinking about etiquette. You're asking whether it is indeed the rule here to send a thank you note after a party. Well, you need a lot of facts. You need to know what other people are doing and so on. But here's one way of doing it. First of all, do most people, most of the time, tend to send thank you notes? Furthermore, do they use it to guide their own behavior? Do they criticize others and so on? Do they accept it from the internal point of view? If no, it's not a social rule around here. Right? So you can even use it as a an etiquette guide. But more importantly, you can use it in order to understand the nature of etiquette rules, which is what we're doing here. And as I said, all of this is interesting regardless of the law. But back to the law. Something we could do, but Hart does not do, is to require that a necessary condition for the legal validity of each and every norm is that it's a social rule. So the norm that you should pay your taxes in this and that time with this and that amount and so on, that's can only be legally valid if it itself is a social rule. That is, if most people abide by it most of the time, and also if they accept it from the internal point of view. But that would not be a plausible requirement. It would be too strong. Clearly, there can be legally valid norms within a system, even if those norms themselves are not backed up by this kind of huge social practice. It seems like the right thing to say about the level of social practice is that what it backs up is not a specific legal norm, but the legal system as a whole. That was a huge point for Hans Kelsen, whose picture is right there, and from which Hart, to an extent, takes this emphasis on the legal system rather than a legal norm. So what you want to say is roughly that a norm is valid, a norm is legally valid if and because it is rendered legally valid by being a part of a legal system. But a legal system is valid, and now you need to plug in something about social rules and about the internal point of view. How do we do that? Well, according to Hart, this sociological stuff works on a more general level via what is often called the rule of recognition, or in some texts, the rules, plural, of recognition. The system determines which norms are valid, and it does it by incorporating a rule of recognition. What the rule of recognition does is it determines which norms are a part of that system. So it recognizes other norms as a part of that system. That does not mean that the rule of recognition has to be written. It doesn't have to be explicit. I think the best analogy to use here is the analogy to the rules of a game, but it has to be an informal game. So think about the distinction between, I'm going to say football because that's how we say it here and in Europe. For US English, it's called soccer, right? Well, if you play like serious football, then there are clear rules. I guess you can probably find them on FIFA's website or something. But if you're playing a kind of friendly game of football, just in the neighborhood or in the park, then there are different rules. There are similarities, obviously, to FIFA's official rules, but they are different. They're not written anywhere. And pretty much everyone gets them. Usually, for instance, there is no offside. That's just a part of how you play it when you play it among friends in the park. Everyone knows it. Everyone appreciates it. Everyone guides their behavior. If someone shouts offside, everyone will criticize them because they're not following the right set of rules for this informal game, right? So it's a social rule. And it's somehow embedded in the practice without being explicitly stated. So this is how I think of the rule of recognition according to Hart. The rule of recognition is the rule according to which officials in the system recognize other norms that are legally valid within that system. They play the recognizing rules game. And when they do it, they're pretty good at it. Officials, usually, not only, but usually judges, are pretty good at determining which norms are and which norms are not legally valid. That's a part of that practice. And just as with an informal, friendly game of football, it's not as if there are rules and then there's the practice of how we play, but rather it's how we play that makes it the case that those rules are in place. Similarly, it's how we recognize rules here that makes it the case that those rules are legally valid. So the rule of recognition, or the practices that it encodes, are not tracking an independent reality of legal validity. They render certain norms legally valid by recognizing them. So this is the picture we get of legal validity according to Hart. Notice that what this means is that the practice theory of rules does not apply to every legally valid norm. In particular, there is no need to accept the different legal rules from the internal point of view. What applies, where the theory of rules applies, is specifically to the rule of recognition, and more specifically yet to officials. It's officials who have to accept the rule of recognition from the internal point of view. That's what captures the idea of legitimacy that was so badly missing in Austin. Okay, so it's time now to introduce the term that you may have heard of already. Well, I mentioned it, but you may have heard of even before me mentioning it. And it's a central term in these debates. That's the term legal positivism. So let's see what it means. Now, Hart's theory is, and Hart is really clear and honest about characterizing it in this way, it's really a piece of armchair sociology. So a part of it is conceptual analysis of what it takes for rules to exist. And then there's some sociology, except done not empirically, but as it were from the armchair. And it's much more plausible than Austin's. So one thing is that it's really not easy to come up with counterexamples to Hart, certainly not as clear-cut counterexamples as you can come up with to Austin. Can you think of a system that has a social rule determining validity within the system, and yet that does not amount intuitively to a legal system? That does not sound plausible to me. Perhaps you can. It's certainly worth spending some time on this challenge. Or in the other direction, can you think about a legal system that does not satisfy these criteria? And again, it's not going to be easy. Again, not perhaps impossible, but not easy to fill in the details. Or here's another exercise. Go back to the slide with some of the problems for Austin. See whether Hart does better. I mean, spoiler alert, he does. That's a kind of the way in which this session goes. But you can check to see. And if you don't see how Hart does better, then you have to rethink about Hart's theory and to appreciate its advantages. So I do think that Hart's made improvements compared to Austin. But he also took some of these things from Austin. And in particular, he maintained the thought that there's a strong distinction between what the law is and what the law ought to be, and the fact that the law is a social phenomenon. And this is what is at the heart of thinking about what is often called legal positivism. Now, I owe you a characterization or a definition, right? Legal positivism is a technical term, and so it should be introduced with an explicit definition. It's not like we have intuitions about the term legal positivism. I'm not going to do that exactly, not because it's not a legitimate requirement on your behalf, but rather because it's controversial how to even characterize legal positivism. It makes some of this literature a bit annoying. But here's at least one good characterization, so without pretending that it's uncontroversial or obvious. And also because, as you know, I don't care about definitions, and neither should you. We want to understand the views and not what they're called. But anyway, here's one fairly clear view that often goes by the name of legal positivism. And it's the conjunction or the combination of two claims. The first one is called the social thesis. What determines legal validity are social facts alone. That is, not moral facts. When we're talking about social facts here, typically what we want to contrast them with are moral facts. If you want to know whether a norm is legally valid, you should look at social facts. You don't care about whether, say, the norm is just or not. And the other thesis is often called the separation thesis, namely, there's no necessary connection between legal validity and moral content. It's one thing to ask whether a norm is legally valid. It's quite another to examine its content and to check whether that content passes some moral test or is above the bar, the moral content-based bar. So if you accept both of these, what this means is that you are a legal positivist. Congratulations. And what it also means, and more importantly, is that you try to maintain a clear distinction between what the law is and what the law ought to be, and you respect the thought that legal facts are social facts, or that the law is a social phenomenon. So what do you need to know according to legal positivism in order to know whether a norm is legally valid? Well, it seems like the main thing you need to know here are things like what the rule of recognition in your specific jurisdiction is. And then you need to know, right, so these are just social facts. This is just, what are those people, judges, perhaps judges in the Supreme Court, what do they recognize as parts of the system and what don't they, right? For this you need to, I don't know, maybe read their opinions or something like that. And then you need to know about the specific legal norms, whether it satisfies the criteria recognized by the rule of recognition. And that's it. You need to do sociology. Perhaps in a suitably broad sense of sociology. There are going to be quite a few controversies in the literature between positivists. Right? Some of the deadliest wars are internal, as it were, certainly in academic circles. And we're going to get to at least one of these later on, but there are also some problems and challenges coming, as it were, from outside, from non-positivist directions, and we're going to be talking a little bit about them as well. But before we do that, I really want to preempt some problems and some misunderstandings. So this is really crucial, because whenever I teach this stuff, these misunderstandings come up, and it's important to rule them out at the earliest stage possible. And in order to do that, what we need to discuss is not just what positivism does say, but also, and perhaps more importantly, what it does not say. So positivists do not deny, of course, interesting connections between morality and law. Recall that they do deny a necessary connection between legal validity and moral content. But that leaves room for many other interesting relations between morality and law. We just saw something about that relation from Hart, say about legitimacy or aspiration to legitimacy. There's going to be more. Here's one that comes from Joseph Raz. That's Raz's picture right there. Perhaps something about the claim that, perhaps something about law aspiring to legal and maybe moral authority. Right? So the point is that the law is not necessarily authoritative, because some legal systems are illegitimate, but the law at least hopes, as it were, but also claims to have genuine moral authority. Now, if that's true, that necessarily the law claims moral authority, that's a really interesting relation between morality and law. But it's not one that positivists need to deny, and indeed Joseph Raz is a leading positivist. It's a different kind of relation. All they need to deny is a necessary connection between legal validity and moral content. So that's one misunderstanding that it's important to preempt. Here's another. Positivists certainly do not suggest that legislatures should not care about morality. Right? They just say that whether a norm is then going to be legally valid is going to depend on things like how many people voted for it or against it when someone said, okay, let's vote. That's pretty much it, right? But of course they think that legislators should be guided by morality. Everyone should. So positivism is perfectly consistent with thoughts about morality guiding law, by guiding lawmakers or in other ways. Positivists should be entirely happy with the normative discussions that we have been having throughout this course as a way of thinking, whether we should improve the law in some ways, or whether the law, a certain legal arrangement, is morally justifiable, and so on. And nothing here is in any tension with legal positivism. Also, positivists are not committed to the thought that there is an absolute duty to obey the law, regardless of how morally reprehensible, or with the thought that judges have such an absolute duty. Why would positivists be committed to that? Why would anyone be committed to that view? Right? If you see a serious philosopher putting forward the view and then someone else characterizing it as committed to a ludicrous claim like this one, then you should probably reread the serious philosopher's view. Right? There seems to have been a mistake in the interpretation. No one accepts this, nor do, in particular, legal positivists. They just want to insist that it's one thing to ask, what does the law say? What is the content of the legally valid norms? And then it's a different question, what should be done about it? And it's quite possible that you should break the law on a specific occasion. It's quite possible, if you're a judge, that what you ought to do is to lie about what the law is, in sufficiently extreme circumstances, perhaps. But none of this matters, that what the law is determined, if positivism is right, by these social phenomena. So the fact that you may want to, or it may be important on some occasions, to disobey the law, even from the bench and so on, that's not a kind of thing that positivists under pressure may want to accommodate. That's a feature of the view. It's a part of the insisting on a strong distinction between what the law is and what the law ought to be. We'll see that this raises problems later on, but the kind of problems it raises are different. It doesn't raise problems to whether positivism is false. It raises problems to how much we should care about the entire debate. But that, as I said, is a different point. In fact, sometimes it seems like, look, with these understandings in mind, once you are not mistaken with a caricature view of positivism. How can anyone not be a positivist, a legal positivist? And so to this we turn.